Hello, I'm Vanessa Gordon. I'm the owner attorney of Gordon Law in Lincoln, Nebraska. And today I'm going to talk about two specific kind of family law legal actions that can occur after you've already obtained either a decree of divorce or a decree of paternity or a prior order of custody and child support. So there's an order in place. And sometimes following that, legal parties are a little bit confused about what types of post-order actions they might need to consider. So we're going to talk about contempt first. What's important to know about contempt is that the purpose of contempt is to enforce the orders that are already in place. It's not to change or add to or subtract from the orders that are in place. It is to put consequences in place for one side or the other not doing the things that they are already ordered to do. Contempt can be a little bit confusing because it can go by a lot of different names. I've seen it filed as application and affidavit for an order to show cause. So order to show cause is one of the titles that it can be given. A verified complaint for citation for contempt is another one you might see. And sometimes people kind of mix and match from the various titles. But basically what you're looking for is whether the party filing this is stating that there is in fact an order in place. Someone on the other side was ordered to do something and they are willfully and contumaciously refusing to follow the court order. And as a result, they should receive some form of punishment or consequence. So the most common ones that I see as a family law attorney are either financial, where a party is significantly behind in child support or has not contributed to childcare costs or to medical costs, or sometimes with joint custody orders, they're supposed to be splitting certain expenses for the children, such as school lunches or clothing or private school tuition. Those types of things were included in an order, and one of the parents is not following that order and is significantly behind. And the other option or the other type I see regularly is related to visitation, where a parent is not returning the children or not allowing children or sending children to go for the other parent's parenting time. So the process for trying to enforce an order that's currently in place is to file some form of affidavit or verified complaint, something that tells the court, here's the order that's in place, what's been going on, and that we believe this to be willful and contumacious disobedience by the other side. Then the judge will say at first blush or at first glance, after reading that affidavit and any attachments, or the verified statements, will say, yes, if things are exactly as the filing party says they are, it appears to meet the definition of contempt. And the court will then issue an order stating that the other party, who's alleged to not be following the court orders, needs to appear in court and show cause why they should not be held in contempt, why they should not be punished. It is very important not to miss that court date once that's served upon someone, because that could lead to a warrant for an arrest. So it's sort of a quasi-criminal type of action, because we take those orders very seriously in family law. Typically, you'll have two hearings for a contempt action. You'll have the initial sort of admit or deny, where a party may, state, yes, I haven't been paying, I've caught up now, put me on a plan, or no, I didn't do that, or there's a very good reason why not, I was hospitalized, I lost my job and I wasn't able to file I had COVID was a big one we see sometimes. And so they have an option to do that. They can also request a court-appointed attorney if they can't afford their own, because jail is the ultimate hammer, the ultimate consequence that can be held over their head. Also, to purge themselves of a contempt, if the court finds they were violating willfully and contumaciously, they can be put on a purge plan. typically for payment of not just the underlying order, but if the filing party had attorney's fees, those can be at issue. Sometimes there's a fine or an amount that needs to be paid to be a get out of jail if jail is ultimately ordered. So that's a very whirlwind tour. But the most important thing I want everyone to take from this explanation is that contempt is appropriate when you're trying to enforce the current order. You do not use contempt actions to change a current court order. So if the issue is more of, a parent can never pick up the child at the start of their parenting time because their work schedule changed, then you may be looking at something where it is more of a modification of the current orders. So while most non-financial matters can be from time to time modified by agreement between the parties. If something's going to be a permanent or long-lasting change, then typically there needs to be some form of modification. And modifications can be agreed to, or they can be litigated because the parties don't agree that anything should change or what should change. So the legal standard for modification or changing a current court order is that there's been a material and substantial change in circumstances. And that change in circumstances is so different that if the court had known what that change was or that change would happen, the court would not have entered the original orders. So, and then the second prong of that is it has to be in the best interests of the children that are affected. So, for example, child support, the Nebraska support guidelines state that the change needs to be 10% or more. So if someone would pay $5 less in child support, for example, that would not be generally considered a significant change. I've also had situations where perhaps the parties, one of the parents lived in Seward and one of the parents lived in Beatrice, and now both are about Seward's about a half-hour drive from Lincoln. Beatrice can be up to an hour depending on weather. When you look at those distances, if a parent was in Lincoln and a parent was in Beatrice, and now the parent that was in Beatrice has moved an hour away from the parent in Lincoln in a different town, that's probably not a change in circumstances that's significant enough to warrant changing anything. However, if one of the parents has now moved to Scotts Bluff from Lincoln, then yes, that's a far enough geographical issue they know they're moving out of state. That's always a big enough issue that would require a modification of the parenting time, because geographically often those were set up with the understanding the parties were a certain distance apart that they'll no longer be. Also moving closer together. If the parents live 2 hours apart and now are going to live across the street from each other, there may be a reason to change to more of a joint custody or more parenting time arrangement because the geography allows for more fluid going between houses. So with the modification, it works the same as an original litigation in that the complaint is filed. The other side must be served. They have an opportunity to answer. There can be discovery to find out the details of the change or what change has occurred. And that can go all the way up to mediation and co-parenting classes again, even if they were done in the underlying case, and a trial if the parties can't agree how to change things or whether things should change at all. The major difference between a modification, where you're seeking to change a current court order, and the original case is that typically temporary orders are much more difficult to get. There needs to be some sort of true emergency or safety issue to make a temporary change. In most cases, most judges will not make a temporary change on a modification, primarily because it would require the court to sort of prejudge the case without the benefit of all of the information. So again, if you're going to file to modify or you like to change an underlying order, then that would be a modification. If you want to enforce or gain the cooperation of the other side in complying with the current orders, that would be a contempt action. I hope this information has been helpful to you. Both contempts and modifications are things that Gordon Law regularly assists clients with. So if that's something you're considering, we would invite you to schedule a strategy session with us today. Thank you.